Welcome to the CCN Mexico Report podcast, an overview of Mexican legal, business, and political developments presented by the international law firm of Cascio, Cavazos & Newton. The content presented is for information and educational purposes only and should not be understood as legal advice.
Welcome to the first edition of the CCN Mexico Report podcast. I'm Rob Barnett, and I have the pleasure of sharing with you articles we have recently published in the CCN Mexico Report. In his article, 300 Palabras, Dr. Mario Melgar Adalid writes about Mexico and the Morena Party and will it remain in power. One of the big questions occupying the minds of millions of Mexicans is whether the Morena Party, the party currently in power, will survive the 2024 elections and the conclusion of President Andrés Manuel López Obrador's six-year term. In general, the debate regarding President López Obrador's intention to potentially seek re-election is now over. Such a re-election is currently legally prohibited. Some potential candidates to take the mantle of the 4T, as the current president calls his movement, in the 2024 elections include Claudia Sheinbaum, Marcelo Ebrard, and Adán López. This alone indicates that the principle of no presidential re-election enshrined in Mexico's constitution will be maintained. Apart from these signs, no evident opposition to the current regime appears to exist. The custom of the president having substantial power during the first 5 years of his term will hold, and the sixth and final year of the term will be reserved for the leading candidate in the upcoming election. President López Obrador has proposed radical changes to the country's laws and policies, and some feared such changes would establish a left-wing regime affiliated with Latin American movements such as the ones in Venezuela, Nicaragua, and Cuba, which limit freedom of the press, respect for human rights, and tend to favor a more authoritarian state-controlled economic model. For now, the most obvious signs show a populist government which proposes progressive policies to address social inequality, but does not break Mexico's existing constitutional framework. This is also true in areas such as the separation of powers and maintaining a free market economic system, notwithstanding worrying signals that have emerged from the current administration's energy policies. Further, and encouragingly, there have been no major ruptures with the United States and its relationship with Mexico. These could have damaging effects for Mexico, and on the contrary, the Mexican government has enjoyed a good bilateral relationship with the U.S., as shown in its support to sign the United States-Mexico-Canada Agreement, USMCA, which succeeded the NAFTA. Thus far, the government has followed and respected the Mexican Supreme Court's rulings, even if such decisions ran counter to its interest. Only time will tell if the 4T movement is here to stay, which will depend largely on the successor to President López Obrador. This question will be decided when Mexicans vote in 2024 to chart the future course of their country. CCN partner Jose Maria Lujambio writes in his article, Defending the Mexican Energy Regulatory Commission, or CRE. Some time has passed since Mexico's president submitted his initiative to amend the Constitution on energy matters. The Chamber of Deputies, or lower house of Congress, received this proposal, but has not acted. Since then, much has been written and said about the proposal's aims and negative consequences it would have if approved. Most of the analyses have dealt with the material aspects of the initiative, such as re-including all electricity generation and supply as exclusive activities of the Mexican government, canceling permits granted for such activities, and ensuring that the government-owned Federal Electricity Commission, or CFE, generates at least 54% of Mexico's electricity requirements. However, there has been little discussion about the organic aspects of the proposal, which include transforming the CFE into a state agency with constitutional autonomy, integrating it vertically and horizontally, with few exceptions, bringing the system operator known as the National Energy Control Center, or SENACE, which operates the national electric system, back under the CFE, And lastly, but very importantly, eliminating the Mexican National Hydrocarbons Commission, or CNH, and Energy Regulatory Commission, the CRE. The initiative proposes to delete the 8th paragraph of Article 28 of the Mexican Constitution, a precept dedicated to enshrining free economic competition. Today, this paragraph establishes that the executive branch will work in coordination with regulatory bodies such as the CNH and CRE in important energy matters. In fact, the third transitory article of the reform decree states that the CNH and CRE would be, quote, suppressed, and that their structure and functions would be absorbed by the Department of Energy, or CNR. Unfortunately, the initiative's explanatory note does not justify the suppression of these regulatory bodies and merely argues that their creation took fundamental decisions away from the government and entrusted them to bodies which are not, quote, politically responsible. If this refers to the institutional separation of the CRE from electoral politics, this was indeed the intention beginning with its creation in 1994 as a body of the CNR, with its own law and powers of authority since 1996. Later, it became an independent federal agency conceived in the 2013-2014 energy reform, distinct from and at the same level as the CNR, yet coordinated by this latter agency. If the initiative is approved in its terms, the powers of the CRE would become the responsibility of CNR as appropriate. However, none of what currently corresponds to the CRE in the electricity sector would be shifted to CNR, since the reform would turn the CFE into the state-owned agency responsible for the entire strategic sector of electricity, including the activities of the sector's value chain, planning, control of the electricity system, and dispatch of generation. The CFE would also determine matters related to transmission, distribution, and end-user tariffs, which are currently determined by the CRE. In addition, generation and supply permits would no longer be granted, nor would there be any records in the registries of traders or qualified end users. In the case of both the electricity and hydrocarbons grids, the CRE now approves the general terms and conditions for rendering services, including the maximum rates that companies may charge, all toward meeting the key principle of open and non-discriminatory access. Without a collegiate body charged with transparent deliberation, the executive branch's instructions would translate into direct orders down the chain of command of the federal government, to the detriment of the certainty essential for promoting investment in the energy sector. Instead of making the constitutional mistake of eliminating the CRE, serious thought should be given to its strengthening by providing it with greater autonomy outside the sphere of the executive branch. Regulators should commit to serving the public interest and should not promote the specific interest of any particular company, even if they are state-owned enterprises. Mexico's SCT issues updated bill of lading forms for use by federal motor carriers. CCN partner Ramon Concha Hein writes that on December 16, 2021, the Mexican Department of Communications and Transportation, or SCT for its acronym in Spanish, issued a decree updating the bill of lading form used by federal motor transportation carrier services. The decree was published in the official Journal of the Federation to update the bill of lading forms previously issued by the SCT. The updates stem from new regulations issued for supplemental bills of lading, or supplements, which are incorporated into the Mexican Internet Digital Tax Invoice System, or CFDIs. The decree establishes that the supplement will constitute legal title and evidence of the contract between carriers and their clients, shippers, and that the conditions set forth in the exhibit to the decree will govern the relationship between transportation carriers and such clients. The decree revokes previously applicable regulations issued on December 15, 2015. This means that going forward, bills of lading and their templates used under prior regulations will no longer be valid. The decree contains a single exhibit setting forth the terms and conditions of services governed by a CFDI supplement, among which the most relevant include Clients are responsible for delivering and providing all information and documents needed to hire transportation services, and for complying with the document requirements mandated by applicable laws and regulations, including the proper fulfillment and compliance when issuing a CFDI supplement. If the load is not taken from the carrier's facilities at the agreed time, or within 30 business days from the date on which the load is available to the client may conduct a public auction to sell the load per the terms of the Mexican Commerce Code. For a carrier to assume liability for the replacement value of the load for any risks, including acts of God and force majeure, the value of the load must be expressly stated, and the parties must agree to an additional charge equivalent to the insurance premium in this case. And the collection of such charge needs to be included in a CFDI and supplement. If no additional charge is agreed to and coverage is waived, if the load is lost, the carrier will be liable only for the equivalent of 15 measurement and update units, or UMAs, totaling 1,433 pesos per ton, for shipments exceeding 200 kilograms, and 4 UMAs, 344 pesos, for shipments under 200 kilograms. Note this provision contravenes Section 5 of Article 66 of the Law for Highways, Roads, and Bridges. The motor carrier's clients may make claims in writing for any missing load or damages solely within the 24-hour period following the delivery of the load by the carrier. This provision runs contrary to the terms for claiming a load or damages under Article 592 of the Mexico Commerce Code. Shippers hiring Mexican motor transportation companies should execute written transportation services agreements, specifically including the motor carrier's service terms and conditions and waiving the provisions of the decree. This is especially true given that the decree appears to mainly benefit carriers, leaving their clients and users of federal motor carrier transportation services at somewhat of a disadvantage. CCN attorneys Pablo Saenz and Maria Fernanda Magallanes have written an article on Mexico's Social Security Institute announcing a flexible program for granting paid sick leave. On January 11, 2022, the Technical Council of the Mexican Social Security Institute, or IMSS for its initials in Spanish, announced the COVID-19 permit process will be relaunched as a result of the heightened risk of infection recently caused by the Omicron variant. The COVID-19 permit provides employees with the possibility of obtaining paid sick leave for up to 7 business days without having to visit a medical unit of the IMSS. The purpose is to avoid symptomatic employees coming to the workplace and potentially transmitting the virus and damaging the company's normal activities. The COVID-19 Permit version 3.0 establishes that through a digital application involving a questionnaire about symptoms, vaccination status, and pre-existing conditions, an employee may obtain the COVID-19 permit and be granted paid sick leave up to 7 days. The council also stated that working mothers who qualify for maternity leave will be able to file for such leave remotely through the Social Security Digital Services platform, thus avoiding the risk of infection by visiting IMSS facilities in person. The announcement requests employers to avoid requiring COVID-19 tests paid by the employee and provides that the employer should cover these costs. Finally, the announcement asks employers to help employees who require assistance to complete the forms necessary to obtain the permit. It is vital for employers to be in constant communication with their employees and working mothers infected with COVID-19 so the company can obtain the paid sick leave permits and avoid paying double during the leave or apply non-justified discounts for not coming to the workplace. CCN attorney Eduardo Parroquin Patiño writes in his article, Improvement to Mexican Legal Proceedings in the Wake of the Pandemic. When the pandemic arrived in 2020, the way in which certain legal proceedings were conducted changed significantly, in some cases radically. These pandemic-related changes may be the most important and significant updates, not resulting from legislative amendments, but rather from adjustments to the existing legal framework in place. The changes have led to certain modifications to the way Mexico's legal machinery was conducted, with the aim of achieving a modernized and efficient system, appropriate to the prevailing health and safety needs present over the past 2 years. Those who saw the most changes in their practice are litigation attorneys and court personnel. Since prior to the pandemic, the law and tradition dictated that court files always had to be kept physically and any legal action be evidenced on paper. However, the isolation and social distancing required by the authorities brought rapid technological advances that have allowed parties to continue to conduct legal proceedings even when the resulting delays caused by the scheduling and spread of infections in the workplace occurred. Such technological advances have been implemented by using identity verification and virtual document delivery systems through platforms created specifically by the federal and local judicial authorities for these purposes. Such systems have given litigants the tools needed to review case files virtually through a website or mobile application and to be able to file motions without the need to be physically present at the courthouse, as has always been required in the past. These updates do not imply that courts are now not required to keep a physical version of the case file, but with each passing day, the migration to a virtual file management system, as opposed to a physical one, is becoming more of a reality, considering the efficiency and convenience of software through which these documents are created. Likewise, handling a virtual file in the past 2 years has improved guaranteed access to justice as provided by the Mexican Constitution and international treaties. Without such advances, and given the suspension of in-person activities in Mexican courthouses, it was once considered impossible to ensure parties are provided sufficient access to justice. In this context, the various state courthouses throughout Mexico have developed the platforms needed to file motions virtually and have even developed their own advanced electronic signature. This has occurred in the Estado de Mexico, Coahuila, and Tamaulipas, among others. This requires the litigant to visit the court's office for a verification of identity. It should be noted that the federal judiciary was able to make available the acquisition of the advanced electronic signature to all its users through remote verification means, pursuant to an interinstitutional agreement with the National Electoral Institute, or INE. Such efforts allowed for and guaranteed access to justice at a time when the public was not allowed to physically review their case files. These advances allowed the judicial system to continue in motion and to be suspended as little time as possible during the pandemic, especially considering that the administration of justice is an essential activity in any legal system. Without doubt, in Mexico today, there is better access to the court system and to the administration of justice, considering that access to judicial files may be carried out from anywhere in the world and at any time through an ordinary internet connection. Note that to date, certain local courts which have not achieved the same technological advances means that they are less able to operate and makes access to justice somewhat more difficult in these cases. The result of all these developments occurring in the wake of the pandemic is that the Mexican judicial system has made technological advances, which translate to and materialize in better administration of justice, reduction of time and cost, and a better general perception of the work carried out by Mexican judicial authorities.
Thank you for joining us for this edition of the CCN Mexico Report podcast. Subscribe to the CCN Mexico Report newsletter at www.ccn-law.com to receive the full text of this edition's articles. This podcast is copyrighted 2022 by Cascio Cavazos & Newton, LLP. All rights reserved.